Hello everyone, welcome back to another episode of Courts Today by Livelaw, your one-step destination for the latest and fastest legal updates. I'm your host Urvashi Chauhan, bringing you day-to-day happenings, landmark judgments, crucial rulings and expert insights into the world of law. Starting with an update on the NEET undergraduate exam 2024 controversy. On 23rd July, the Supreme Court bench of CJI Chandrachud, Justices J.B. Pardiwala and Manoj Mishra had delivered the judgment in a batch of petitions seeking to cancel the exam that was held on 5th May because of paper leak and malpractices. But the court had refused to cancel the exam. Today, it was pronouncing the detailed judgment, giving reasons for its 23rd July order. The court criticized the National Testing Agency for the flip-flops it made in relation to the conduct of the exam. The CJI questioned the NTA for allowing candidates to change the exam centers and also for opening a rare door to allow new registration. The CJI also flagged NTA's decision to award grace marks to 1,563 students to compensate for the loss of the time they suffered for being given the wrong question paper. Though later, the marks were retracted and those students were made to appear for a retest. The court highlighted that the NTA gave grace marks to students who answered a question option for a confusing question. However, an expert panel from IIT Delhi found that only one answer was correct for that question. As a result, the court ordered the NTA to adjust the results. Due to NTA's initial decision, let me tell you, 44 students received full marks out of 720. In the judgment, the court has given additional directions to the expert committee, which was constituted by the union government, to examine measures to make the exam process more robust. The committee has been asked to formulate a standard operating procedure regarding the timeline for registration, change of exam centers, sealing and storage of OMR sheets, etc. In the next update, Chief Secretary Naresh Kumar today informed the Supreme Court that Delhi Lieutenant Governor V.K. Saxena was not aware of the need for court permission to cut trees in the southern ridge. This statement was made in an affidavit for a contempt petition against the Delhi Development Authority for illegal tree felling in the area. Justices Abhay S. Oak and Ujjal Bhuyan noted that previous correspondences suggest that trees were cut following the LG's oral instructions during a site visit on 3rd February. The court warned of potential contempt notice against the LG and demanded clarity on whether he knew about the court's orders. The affidavit filed on 30th July states that during his visit, the LG instructed to expedite the project for medical facilities but was not informed about the court's order or the need for the tree officer's permission. The contractor involved also received emails from the DD official referring to the LG's visit and directing tree removal. The court had earlier indicated that emails showed the tree felling was per the LG's orders despite DDA's claim that the visit was for a different project. The court had also criticized DDA for attempting to protect higher-ups and demanded a full disclosure of the LG's visits records. In recent times, several Indian cities have undergone name changes to apparently reflect their historical, cultural and local significance. For example, Allahabad's name was changed to Prayagraj and Faizabad to Ayodhya. These changes aim to restore traditional names and emphasizes the city's historical and cultural identities. In a similar case, the top court has dismissed an SLP filed against the Bombay High Court order upholding the Maharashtra government's notifications renaming Aurangabad city and revenue areas to Chhatrapati Sambhajinagar and Osmanabad city and revenue areas to Dharashiv respectively. The bench of Justices Rishikesh Roy and S.V.N. Bhatti refused to interfere with the impugned order of the High Court. Let me tell you here that several petitions were filed before the Bombay High Court challenging renaming of Aurangabad and Osmanabad cities as well as revenue areas. The Union Ministry of Home Affairs had approved the renaming last year. The PILs contended that the renaming was driven by political motives and fosters religious discord. The petitioner in the PIL challenging Aurangabad's renaming alleged that a campaign was going on in Maharashtra to change the names of all cities which have a Muslim name. The Maharashtra government, however, denied this contention and submitted in relation to the name changed to Chhatrapati Sambhajinagar that naming of a city on a personality held in high esteem by the entire state does not have a religious color. The High Court had refused to interfere with the challenged notification, saying that it did not suffer from any legality. And now, hearing a challenge to this order, the Supreme Court bench has also refused to interfere. In an important development, the Delhi High Court today constituted a committee to revamp and reform the physical, financial and administrative infrastructure of the national capital. Acting Chief Justice Manmohan and Justice Tushar Rao Gadela was hearing the PIL seeking constitution of a high-level committee to probe the death of 3 civil services aspirants who died due to drowning in a IS coaching center basement in city's Rajendra Nagar. The court, while transferring the investigation into the matter from Delhi Police to CBI, said that the committee to be formed will be headed by Chief Secretary of Delhi Government and will also include Vice Chairman of DDA, Commissioner of Delhi Police as well as Commissioner of MCD. It said that whole Delhi infrastructure, physical and administrative, needed a relook. The court said that due to various subsidy schemes, the migration in the national capital is only increasing and so is the population. And the civic agencies in Delhi have no funds to carry out major infrastructure. Furthermore, the court said that the recent tragedies have shown that judicial directions are not followed in letter and spirit by civic agencies, and that administratively, Delhi has multiplicity of authorities who are only passing the buck and blaming each other. The bench also told MCD Commissioner that the civic body must ensure water has a way to flow in Delhi, and if drainage needs to be revamped, the same should be done expeditiously. Coming to a short update on the electoral bonds matter. The Supreme Court has today dismissed petitions seeking to set up a special investigation team to investigate the alleged instances of quid pro quo arrangements between corporate and political parties through electoral bonds donations. The court stated that it would be too early and improper to order an investigation overseen by a retired judge without first using the usual criminal law procedures. It also rejected requests to make authorities recover donations received by political parties through electoral bonds and to reopen their tax assessments. The bench noted that these actions are under the jurisdiction of the Income Tax Act. The bench of CJI D.Y. Chandrachud and Justices J.B. Pardiwala and Manoj Mishra said that issuing such directions now would mean deciding on the disputed facts prematurely. It indicated that the petitions at this point were based on assumptions. In the 2018 firing at Anti-Sterlite protests case, the Supreme Court has today stayed Madras High Court order for investigation into assets of police and government officials. This matter relates to protests in 2018 which were done by Tuticorin agitators against Vedanta Group's proposed expansion of a copper smelter plant of Sterlite Company. The agitators protested against the pollution caused by the smelter, which had contaminated regional water bodies and led to severe health problems for the residents. The police allegedly opened fire on the protesters on 22nd May 2018, which allegedly led to the death of 13 persons. Before the Madras High Court, a petition was filed by Executive Director of People's Watch, Henry Tiffin, seeking directions to the NHRC to reopen the case of killing unarmed protesters, as the NHRC had closed the suo motu investigation into the matter. Last month, on 15th July, the High Court directed the Tamil Nadu Directorate of Vigilance and Anti-Corruption to investigate the assets of all police and government officials named as accused in connection with the firing. Then, on 29th July, the High Court expressed dissatisfaction over CBI's failure to bring to light the original culprits in the 2018 police firing incident. The director of DVAC was granted 3 months to complete a fresh inquiry and submit its report to the bench. Against this order, the police officers have approached the Supreme Court. Today, Senior Advocate Kapil Sibal, appearing for the police officials accused in the firing, submitted that the report of the NHRC was in fact in their favor. He stated that while the protests were going on for 99 days, it was only on the 100th day that the police did the firing upon imposition of Section 144 of CRPC. He added that the NHRC report itself mentions that the police officials were attacked by the protesters who were larger in number and overpowered the officials. The bench led by CJI D.Y. Chandrachud agreed to consider the matter and directed that the impugned order of the High Court shall remain stayed till the next date of hearing. The Supreme Court has today dismissed the petition filed by Asianet News Network Kannada channel, Asianet Suvarna News and journalist Vishweshwar Bhatt challenging a Karnataka High Court order. The High Court had refused to quash criminal defamation case against them filed by actor Divya Spandana for allegedly linking her to IPL spot fixing scam. It was alleged that the news channel on 31st May 2013 had telecasted the news of the alleged involvement of the Kannada film actress in the betting and spot fixing scandal, and that she was time and again named and her photos and videos were shown while the news was being telecasted. The counsel for the news channel, however, contended that the telecast nowhere mentioned her involvement in the betting scam. However, the bench led by CJI Chandrachud refused to entertain the matter. It noted that the news bulletin actually repeatedly mentioned the actress's photos and videos during the telecast, and a genuine case to quash the defamation proceedings was not made out. In the suit filed by state of Tamil Nadu alleging that Kerala's construction of mega car project in the Mullaperiyar catchment area encroached upon the area leased to it, the Supreme Court has framed issues arising for consideration. The Mullaperiyar Dam was constructed between 1887 and 1895 to divert water of the west-flowing Periyar River to arid regions of the east, including areas of the Madras Presidency. After the independence of India, the Periyar Lake Lease Agreement signed in 1886 was renewed by the states of Tamil Nadu and Kerala, giving Tamil Nadu rights over the land and water related to the dam, as well as authority to develop hydropower projects at the site, while Kerala received rent. As a consequence, Tamil Nadu has been operating the Mullaperiyar Dam, which is situated on Periyar River in Kerala. In 2014, the present suit was filed by Tamil Nadu, aggrieved by construction of a mega car park by Kerala in the Mullaperiyar catchment area. Through the suit, Tamil Nadu sought to permanently restrain Kerala from encroaching upon the area leased to the former. The bench of Justices Abhay S. Oak and A.G. Massi have formulated 11 issues in the matter, including whether the suit is not maintainable under Article 31 of the Constitution, and whether the plea on validity of the lease deed of 1886 is not barred by the principles of res judicata. In another update, the Supreme Court bench of Justices Surya Kant and R. Mahadevan today heard the plea by state of Haryana against an order of Punjab and Haryana High Court, which had directed Haryana government to unblock the Shambhu border, which was closed in February this year, to prevent the movement of protesting farmers from Punjab to Haryana. The matter was today adjourned, giving time to the states of Haryana and Punjab to suggest the names of neutral persons who can be included in a committee to negotiate with the protesting farmers. The bench emphasized the need to inspire confidence in the farmers and constitution of a committee of neutral personalities for resolution of farmers' grievances. The matter was relisted to 12th August on an assurance by Solicitor General Tushar Mehta and Punjab Advocate General Gurminder Singh that the exercise of suggesting common names for the committee would be undertaken. In the meantime, the court has directed that the interim arrangement of Shambhu border blockade shall continue. And lastly, the Supreme Court today refused to entertain a PIL seeking directions to the union and states to take action against superstition and sorcery practices in the country. The PIL sought to direct the central and state governments to take steps to control these practices and protect citizens' fundamental rights. It is called for promoting scientific temper amongst the citizens and enshrined in the fundamental duties of the citizens under Article 51A, Clause D of the Constitution. The bench led by CJI D.Y. Chandrachud disinclined to issue notice in the petition and remarked that the scope of the prayers falls within the domain of a legislature to frame laws. The court also observed that it was essential to focus on educating citizens to promote a scientific temper in the country, something which cannot be achieved merely by filing petitions. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.